for a state when the treaty body gives an interpretation of an article that was not necessarily what was conceived of at the time and does it under the veil or saying that it's customary international law. I completely understand that. Many of these treaty bodies, though, it has to be reminded, are not binding. And states, their determinations are not binding on the states. So the issue of the state's sovereignty is not an issue, and the state can certainly make it clear what its views of that are. I mean, a recent, my area that I worked in before was specifically the law of war treaties, and some of that, how it related to human rights in times of armed conflict. And one of the concerns for the U.S. was the assertion by a treaty body that the International Covenant for Civil and Political Rights, one of the articles, asserted that it wasn't, how can I say this, that the jurisdiction of the treaty was not if someone was on your territory and within your jurisdiction, combined, that's the U.S. interpretation, that and is conjunctive, but either on your territory or subject to your jurisdiction. And the U.S. made clear, no, that's not what was done when it was negotiated at the time, and the treaty body, sorry, you're not binding. So not all of these determinations are binding, and the states can still exert their sovereignty. It is challenging. I spent a long time, several years at the Commission for Human Rights, representing the ICRC there. It was the Commission when I was there, so that's a while back. But also even in negotiating, being present at the negotiations for the treaty to prevent enforced disappearances. And it is disconcerting when, to finally get states to agree, there might be what's called sometimes constructive ambiguity. Even in the enforced disappearance treaty, within the definition of enforced disappearance itself. But I don't think that because there are challenges to implementation, or let's say interpretation, that it means that all international treaties then, because they face this challenge of getting numerous states to agree to each other, that they're suddenly worthless and that we won't agree. Obviously, there's sometimes mechanisms that are binding on states to address differences in interpretation, and or we will see how it's interpreted within the state itself.
Just a very quick response. I think this is a fair critique of international law, of some international law. The law the State Convention probably isn't the best example of this because it is lengthy. It's pretty quite well worked out. There are some instances where there's some disagreements, but they're relatively few. One thing I'll just point to is that that is a critique that can be levied against nearly any law. So imagine any significant domestic law that exists, and you're going to find areas of ambiguity, of disagreement, and there's going to be a need for resolution of those ambiguities and disagreements. That's why we have the kind of litigation system that we do. Now, the question, I think, is that international law is who resolves those disagreements about interpretation. How do those disagreements get resolved? And of course, that's contingent within each individual treaty as to how those questions are resolved. Most of the disagreements over the law of the sea convention interpretation are resolved in one of two ways. One is through diplomatic interaction, conversation at the highest levels about how to interpret an agreement. A second is through arbitration. Those are the key ways. Very, 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 very rarely, agreements might also go to a tribunal that's been set up, but I think it's heard fewer than 10 cases in its entire existence. So that's an extremely unusual instance. So yes, is there ambiguity? Yes, I've criticized human rights agreements for this at length in writing, for having extensive ambiguity within the text. But I don't think that alone is enough to say international law is sort of different or strange in this way. Domestic law is ambiguous as well. Some of the greatest laws, including our Constitution, leave some areas for interpretation. So that by itself, I think, isn't enough to say that we should give up on it.
And to Europe, 4 years ago, every newspaper that I'm aware of in France editorialized in favor of ratification of the European Constitution, from papers on the far left to papers on the far right. There was a referendum on the subject. It lost overwhelmingly, then lost again when it was put to a vote in Holland. This time around, you have the Lisbon Treaty, which, as you mentioned, is about to come into force, which does some of the things that the Constitution was intent on doing. When it was put to a vote a year ago in Ireland, it was rejected, so they had this let's vote again kind of deal where, in part due to exogenous factors like the economic crisis, it was approved. But how do you respond to the fact that at the end of the day, the institutions of the European Union suffer from a crippling democracy deficit, that it is testified to the fact that the weakest branch of the European institutions is the parliamentary branch, and that whenever European issues are put to a popular vote, they tend to be rejected, which is why parliamentary maneuvers are required to bring them into force. How does one justify this, given what seems to be a basic tension and an abiding tension between what Europeans want and what the institutions and the people who staff the institutions and the fonctionnaires claim they want?
Okay, I think there are different responses to that question. First, I would like to mention that it is a wrong view, and I mentioned this, and I disagree with Professor Rabkin about that. It's a wrong view to see Europe as made of nations who gave up on sovereignty. We had to give up on sovereignty, a part of it. We had no choice. If you want to build something, if you want to make a family, you have to give up on something. You were a family, your country was a family from 1787, from a constitutional point of view. We were not. So it's true that we had to give up on some issues, but our constitutions remain first. And maybe one of the first responses to your question is that the people who make Europe, 600 million, a lot of people, the people remain very attached to their own legal traditions, and they remain attached to their constitutions. And the constitution prevails over EU law. It prevails. It means that any country which wants to sign an EU document, binding document, has to modify its constitution before doing this. So, from that point of view, sovereignty is preserved. The second response, I think, to your question is that the rejection of the EU constitution comes from the fact that it was presented as a constitution, and it was not. It was not a constitution. It was made of treaties, pre-existing treaties, and what the people rejected, I think, is the idea of being ruled by something which is not really clear in every mind, because of the reasons you mentioned, because of that huge European bureaucracy. So, to end with that, I would say about sovereignty that we had to give up on sovereignty. Why should you? Why should you? You don't have to. We had to, because of the reasons I mentioned, because of our history, because what happened on our continent, which was completely destroyed after the war. We had to live together. And you know that one of the main purposes of Europe at the beginning was, to make the Germans peaceful. Yeah, sure. It was made to put Germany into a network, a system, which would, avoid what happened twice. So, I think the European Constitution was not a good thing. It was, to me, it was a mistake. The Lisbon Treaty is probably more appropriate to European thinking.
Okay, we're going to go to the audience, and there's a line straight in front.